We oppose the motion.
I understand that, but you can't give me a viable way for you to get everything. Everything includes the video footage, right? You're telling me you can't get your eyes on the video they email you until you're out of jail, but you can't give me any idea when that's going to be. Mr. Bradford, have a seat, sir. Good morning. And Mr. Kaplan, are you ready? All right, go ahead.
Judge, in this case, as you know, the defendant has been charged with third-degree fleeing and eluding. We actually undercharged him. He committed allegedly fleeing and eluding third, and with the prior conviction, it becomes fleeing and eluding second, which is a 10-year felony as opposed to the 5-year felony.
And
Therefore, at the conclusion of the exam, I will ask the court to bind the case over on fleeing and eluding second.
okay, Mr. Bradford, you understand what he just told me?
Yes.
All right. Are you ready to proceed, sir?
No, I was waiting for my discovery.
I don't know what that is. I don't know what you're asking. I don't know what you're waiting for.
See myself.
Okay, any discovery? Okay, all right. Did you have a discovery order? Have you made a formal request for discovery? This is the first time I've seen this file, so I don't have any background on it.
I mean, you told the
That's all right. Take your time.
my place to basically extend your rights. I just
Your entire permission to speak to the defendant and wind up possible any piece of charge, it might change the equation for him like the whole.
Sure. You mind having a discussion with Mr. Kaplan about what options are? Clear?
Your Honor, I'm going to give him a copy of the plea for discovery.
Okay. And I was having my own conversation about scheduling. So what else do you need besides that?
I don't have a video with me, Joe.
No. But we're going to get him discovery so he can prepare his exam. So you want the body cameras? What else you want?
everything from the beginning, I never got.
But sir, everything is not specific enough for me to enforce.
Work. I understand what you want.
Well,
Arraignment papers are not part of discovery. Arraignment papers are court issue stuff.
See, it's.
They're
Further along in this case,
what he just gave you is written discovery. That means that's all the documentation they have. So anything you want that is not documentation, like a body camera, then you got to ask for that. So you've asked for the body cam. Is there anything else you want?
witness statements.
That would be the written, wouldn't that be part of your written discovery?
it would be.
So any written documents, if it ain't in there, they don't have it. And if they come up with it at the exam, they can't use it. Follow me? All right. So other than documents, other than paperwork and the body cam, is there anything else you think you want? Okay, now here's the problem. They usually email digital discovery, right? Okay. Do you have access to that kind of equipment in the jail so you can get it?
No, sir.
Then you can't get discovery. I'm not going to order them to walk down there and hand you a laptop at the jail. That's not what the prosecutor's office does.
There's one that's I'm working on also is. Since this is taking so long, I'm quite sure I can be released on that case by the time they send it.
All right. Are you being held on this one? What's your bond on today's file? Do you know? Okay. All right. So do you have any idea when that's going to be resolved? The other case?
Because waiting on these two cases are coinciding with each other. This one sold me up for that one sold me up for this.
Well, I can give you a new date for an exam on this one, but we still got to get your discovery before that new date. So how are you going to get your discovery? I just asked you that. So if if you give an email address and they email that digital discovery to you, you'll get it.
I'll get it, but I have to be able to see what I'm gonna tell and get it from the else.
But that's what I'm telling you. You're telling me you can't get out of jail until this case is over. This case ain't over until the exam gets done.
Just like go back to court, show them the progress of this. That's all he wants to see.
Okay, so when are you going back to court on the other one? Sure.
You don't need my help serving as.
No, go ahead. I'm always looking for help.
The discovery, it's not our fault, not your fault that you fired 2 lawyers. Judge, now he has the paper discovery, he can read you in the next hour if you don't mind. We're not introducing body camera evidence, therefore, he has no grief at this point.
So you're going just on officer's testimony for PC purposes?
Yes.
All right, so let's try that. You understand what the purpose for this exam is, right? It's not for them to prove to me you're guilty or not guilty. You understand that? Today is just probable cause. They got which is a pretty low burden. I keep saying prosecutor has to convince me 2 things. 1, that a crime occurred, and 2, that looks like, there's reason to believe you were involved in the crime. You understand that's the burden?
Yeah.
It's a yes or no question, Mr. Bradford. Do you understand the burden? Okay, so what he's telling me is video's not coming in today. He's just going to put that guy right there on the stand, ask him some questions, and establish some facts through his testimony. Okay? I'm assuming, is that your report that he's holding in his hand, Officer Pearl? All right, so his report from the incident is what you've been given. So today, we probably don't have to get into digital discovery. We can get through today, then you'll have something to talk about at your next case.
No, that's the right officer. That was on his case. I don't know.
We're saying it is, so
I don't know if it is either. I wasn't there. But that doesn't change what I'm talking about. So his suggestion is I hold for a minute, just pause. We'll put you back in the cell, give you some time to, digest that paperwork in your hands. And then we'll come out here and we'll do a probable cause hearing, not a trial. And then at least we can accomplish something. So you're further along when you go to your next case. And hopefully you're that much closer to being on the street before this trial comes up downtown.
Somebody ripped off of this.
Okay. Did what I just say make sense to you?
I don't know. So I'd like to be adjourned so I can get everything, so I have everything,
We have opposed the motion.
I understand that, but you can't give me a viable way for you to get everything. Everything includes the video footage, right? You're telling me you can't get your eyes on the video they email you until you're out of jail, but you can't give me any idea when that's going to be. Am I missing something? I'm sorry?
You gave me a week, so get everything done.
The court date on the other file, you mean? And you think they're going to release you? What if they don't? Then what?
We're ready to proceed now. We have our witness.
I'm going to hold it, Mr. Bradford. You can appeal me. I'm going to hold it. You want some time to review the paperwork before we hold it? Okay. We'll do that. This case is in recess.
Thank
All right.
you.
Pause. Just. Mr. Bradford, just so I can tell everybody when we're likely to get going. How much time do you think you need before we're ready to go? It's 10 o'clock now. 10:30? Okay. All right. Just so we can all plan. Thank you. Are we ready? Okay. All right. Let's call a witness.
Michael Pearl.
Officer, come on up. Raise your right hand for me. Swear or affirm, tell the truth, the whole truth, nothing but the truth. Watch your step on the ramp. Have a seat in that chair. When you get over there, hand me that box of Kleenexes.
Sure.
I don't expect you to get a little weepy today.
I think I'm good.
Thank you.
Yeah, you're on.
Yes, please.
Hey, Your Honor. Morning, Officer Powell.
Morning.
Sir, how many years have you worked as a police officer?
About 6 years.
Taking you back to June 22nd, 2024, at about 11:20 at night. Were you working?
Yes.
What were your responsibilities, Officer Pearl, on that evening?
Go, respond to calls and perform my regular duties.
Were you in a vehicle or were you stationary?
I was in the vehicle.
Marked and unmarked vehicle? Were you in uniform or plain clothes? Officer Pearl, on June 22nd, 2024, did you meet a gentleman named Nathaniel Bradford?
Yes.
Is his son a record executive? If you want to go over and check, hopefully you know when we speak.
Right,
Let's see where.
we're in a green.
Your Honor, may the
Sure.
record reflect the witnesses identified the defendant, Mr. Bradford.
Noted for the record.
Are you referring to the,
Well, you said you met a man in this.
okay, yes.
So what caused you to interact with them or notice?
I attempted to pull him over on traffic stop.
In the vehicle or was he walking?
Using the vehicle.
You remember the vehicle?
Yes.
What model?
It was a Chrysler Town Country.
You remember the color?
Purple in color.
Was he alone or did he have an occupant with him in the vehicle?
He had a single pass.
Was Mr. Bradford driving or was he the passenger?
He was driving.
What did you notice about his driving?
I noticed that he disobeyed a stop sign and failed to signal his turn
On what street did that occur?
at the intersection of Belleville Boulevard and Sumter Road,
In what community?
the city of Belleville.
What else did you notice about Mr. Bradford's driving?
I observed that after I had activated my overhead lights, his speed increased significantly.
What does that mean he was a police officer?
He was attempting to flee or elude me.
Officer Pearl, when you first noticed the defendant, and he disregarded the stop sign, were you next to him, behind him, or in front of him? In front of his vehicle.
I was, he was coming at me, so we were, he was in front of me.
Where was your vehicle when Mr. Bradford began to drive at a higher rate of speed?
I'd say in the area of Sumter Road and Owen by 600 Sumter.
Your Honor, I would like to address the court and say that request earlier to increase the charge, the defendant has enough pain like that, I'm not to seek that increase.
Thank you.
I think
No problem.
Officer Pearl, when if at all did you attempt to take traffic stop? And what point?
I was passing the Belleville Plaza where Dollar Tree is on Sumter Road.
Can you estimate for his honor the amount of time or the distance you spent pursuing this defendant?
About 3/4 of a mile.
What part of, did you have overhead lights and siren?
Yes,
Did you activate either or both or none of those items?
both.
Were they functioning?
Yes.
Did Mr. Bradford heed your request to pull him over?
No,
Remember the time this occurred?
this was just before midnight, I believe.
Officer Pearl, did you form an opinion one way or the other whether the defendant knew you were trying to pull him over?
Yes.
What's the basis for having an opinion? What is your?
Can you rephrase the question, please?
Sure. And you activated your overhead lights,
Yes.
and you said you didn't stop for it,
Correct.
so about a mile,
Yes.
and you increased speed.
Yes.
Did you form an opinion whether he knew you were there trying to pull him over?
Yes. My opinion was he was actively trying to flee.
But sir, ultimately, did you stop him?
Yes.
And when you stopped him, did you make any observations about his state of sobriety?
Yes.
What did you do which enabled you to detect and notice his state of sobriety?
As Mr. Bradford was exiting his vehicle, a partially full can of Corona beer fell out of his lap. As he was being taken into custody, I observed him having bloodshot, watery eyes, slurred speech, and he admitted an odor of intoxicants from his breath was stolen.
Did you inquire of him whether he had consumed any alcohol that late afternoon or evening?
I don't remember if we inquired on his alcohol intake that night.
Tell the judge the status of Mr. Bradford's driver's license on it.
Revoked.
How do you know that?
His return and leave is leave that.
Now, without telling us the results, did you perform a PPT?
No,
Did you make any efforts to gain any blood or breath from him for analysis?
I asked him if he would be willing to submit to a chemical blood test.
What did he say?
He refused.
Well, did he submit eventually to a chemical blood test?
Yes, we had to get a search warrant.
Did you gain a search warrant?
Yes,
Do you remember from which jurors please? Remember the judge?
I don't remember the exact judge. I'm sorry.
Are you with the one the blood is extracted?
Yes,
Where does that take place?
Orwell can.
Do you remember who extracted the blood or what type of position that person had?
I don't remember her name, but no, she was a registered nurse. I think her last name started with Italy, like that.
Now, what if anything did you notice about the defendant's breath?
It smelled like intoxicants.
Your Honor, at this point, I would move to admit for close exhibit one, if I may approach. I've shown a copy to the defendant.
Thank you.
Your Honor, what I've just tendered to the judge is the lab report issued on July 10 of 2024. Michigan State Police, its laboratory number, if I may, 2X24 9569. And the result of this blood analysis, according to Michigan State Police, Leland Diane Bennett, forensic scientist, the defendant had blood alcohol level of 0.150. So with that, Your Honor, go for the fight.
Are you moving for this to be admitted?
Yes.
Mr. Bradford, any objection to exhibit number one being admitted into evidence? Thank you.
Thank you.
Well, you've already got a month. Mr. Bradford, do you have any questions for Officer Pearl, sir?
Yes,
Okay. You can stay right there or you can come up at the podium, either one.
you stated in the report that you were posting in front of the vehicle down some road. You initiated lights, commercial lights.
No, I initiated my lights, after you passed me, I had to turn around, so I was behind you when I initiated my emergency lights.
So then, how far was it between the places where you had the U-turn?
Yeah,
How far was that between the time you took major U-turn?
it was fairly quick, I turned around and I exited my lights shortly thereafter.
So would you say the car was speeding already, or was it fleeing from who you was?
No, your speed didn't increase until I turned on my lights.
Well, the question was the car already speeding, or
No.
you think that the car was speeding or already fleeing before it stopped?
Let me stop you because I'm confused by the question. I think what you're asking him is, did he think you were traveling over the speed limit before he got behind you? Is that what you're asking him?
Far as the fleeing and moving.
No. Just, is that the question you want to know? Did he think you were speeding while you were still approaching each other? Is that the question? At that point, while you're still approaching? Okay, you understand that question?
I don't believe you were, no. Technically, you can't even be fleeing if my lights aren't activated. Oh,
That answer the question? Okay, any other questions?
Yes. One other. So after you stopped the car, you didn't have footage on your camera. Stop.
I have footage of the entire incident, yes. Yes.
Any other questions? Okay, any follow-up?
Yes.
Yeah, go ahead.
You mentioned to the judge about the stop sign violation. Did the defendant commit any other civil infractions in your presence?
He failed to use his, turning signal when he was turning on the Sumter Road from Belmilla Boulevard.
Lastly, can you tell the judge the speed limit of the beginning area, beginning time when defendant fled to when you finally pulled him over? You know what the speed was?
So, when he initially started fleeing, the speed limit was 40 miles an hour, and he was traveling upwards of 68 miles an hour. And when we
Was
crossed,
the speed limit ever diminished before he was finally pulled over?
yes,
What's the speed limit in that area where you finally pulled him over?
in the area from, the train tracks to, where he eventually stopped his vehicle, it's 30 miles an hour.
Thank you so much. Nothing further, Judge.
Any follow-up questions? Yeah, go ahead.
So, the road you said was Belleville Boulevard,
Yeah,
how far is that from the initial stop? How far is that from when you took the rock?
Let me stop, because once again, I want to clean up your question. I think what you're asking is from where you pulled out onto Sumter Road to when he did the U-turn, how far is that?
Yes. When you seen Lane-
Okay, one at a time. Okay, approximately how far between Bellevilla, Sumter intersection and where you did your U-turn?
less than a quarter mile.
Okay, now the follow-up question would be,
seen the Wilker, stop before, and all of that from point where we were on.
Yeah, I didn't observe, no.
So you did,
I did not observe you use a turn.
so, what?
no, I don't think, he said, I did not see you use a turn signal.
Oh, that's all.
Your question is, could he see
Yeah.
that distance?
Yeah, I could see the lack of the turn signal use, yes.
That's it? All right, Officer Pro, you can step down. Watch your, thank you. Watch your step on the ramp. Right. Okay. Are we ready for argument? Go ahead.
In this case, we have proven to you that the defendant drove with an unlawful blood alcohol. We've also proven to you that he was driving while under the influence based on the observations made by the officer. You're running the speed limit in part of the area where defendant was fleeing is 35 or less. So that would enable us, if it's fourth degree fleeing, to be third degree fleeing. It also becomes third degree fleeing because defendant's a crime of conviction for fleeing and looting, which is part of the packet. We believe probable cause has been established that the defendant committed count one, Your Honor, fleeing and looting third degree, count two, OWI third, death penalty, private license, piggyback one, three, seven. We respectfully would seek a fine over judge on the three counts.
All right, Mr. Bradford, any argument?
Keep that stop, just looking at this. It's story mapping was. Not very fulfilling time. We should have more before.
Okay, well, you'll probably have more before it's time for trial if that's where this is headed. But my question is, do you have any argument to the bind over in response to the argument Mr. Kaplan just made?
Yes, that's what preliminary example.
I'm sorry, say what? This is a preliminary examination. Yeah, this is the probable cause hearing today. What we just did was a preliminary exam.
Sorry about that. I'll see that it proved that this was violent, this was legal. Well, see my name's not, sorry, I'm not gonna do them. I have a single footage of me driving.
Okay, anything else? Okay, so as far as identification, the officer's testimony is enough for probable cause to establish your ID. So I'm gonna bind you over on counts 1, 2, and 3. We'll send you downtown for the next step of the proceedings. The next date is the arraignment on information, which will be next Tuesday at 9 o'clock at the circuit court level. Do you have any questions about that process? All right, I'll continue your bond. Anything else?
No, thank you.
Mr. Bradford, please listen to me. Do yourself a favor, take advantage of the court-appointed attorneys. Dude, I mean, you did a decent job with your questions today, but you're so far over your head on this thing. All right? I tell people all the time, I don't care if you're the smartest guy in the room right now. You still don't have the training and the experience to represent yourself. I know real good attorneys that don't represent themselves when they have problems. Take advantage of the attorneys. Do yourself a favor. I'll sleep tonight. Good luck downtown. Thank you, gentlemen. Be safe, officer.
In this courtroom, the judge carefully listened to every detail before reaching a decision. The court showed patience, fairness, and respect for both sides, while ensuring that accountability remained at the center of justice. The judge's words reflected the importance of responsibility, self-control, and respect for others. Rather than acting on emotion, the court relied on facts, evidence, and the rule of law. This case serves as a reminder that justice is not only about punishment, but also about protecting victims, encouraging accountability, and maintaining public trust. The courtroom once again demonstrated why fairness and law matter in society.
A courtroom hearing took a dramatic turn when a defendant tried to distance himself from crimes he had already admitted to in court. The judge immediately challenged the contradiction, reminding him that guilty pleas are not accepted without clear admissions of responsibility. As the defendant continued explaining, the judge delivered a powerful response. "I wouldn't have taken your plea unless your own words convinced me you committed the crime." The judge stressed that the justice system relies on truthful statements made under oath. With serious concerns about the defendant's changing story, the court halted sentencing and ordered further review before moving forward. A routine courtroom hearing turned tense when the judge learned the victim wanted absolutely no contact with the defendant. Without hesitation, the judge issued a strict no contact